Estate planning. We started this conversation last week talking about what it entails, who needs it, and why it's so important. And we will continue that very important conversation this week. Joining me again tonight on Face the Issues is Richard Shaffer, an attorney at Swartz & Associates, to discuss those questions and more. All of that is coming up right here, right now. I'm Sam Chen, and this is Face the Issues. Good evening and welcome to Face the Issues. Last week we began a very important conversation about estate planning. What is it? What does it entail? And why is it so important? And we'll continue that conversation this evening. So I'm pleased to welcome back Richard Shaffer, an attorney with Swartz & Associates, to discuss this incredibly important topic and continue our conversation from last week. Richard, thank you again for being back. Appreciate your time.
Thank you for inviting me.
Absolutely. We had started a great conversation last week about estate planning, and let's recap some of that. Obviously, for our viewers who haven't seen it, it is available online. They can catch it there. But let's recap some of it. From the 30,000 foot level, what is estate planning, and in your view, why is this so important?
Well, I mean, I guess we should divide it from pre-death to post-death. Pre-death is for life planning, and that is the power of attorney and advanced healthcare directive, which is the two vehicles or documents we discussed last week. This week we're going to talk about wills and maybe a little bit into trust if we have time. And those are documents that, well, while a trust could exist before you die, we're going to talk about the aspect in your testamentary or after your death.
And you said last week that people, the moment they're 18, the moment legally they are entrusted making their own decisions, should begin this process. And just recap for us again why you think that's so important that everybody, even if they're young, should be taking care of this.
Well, for different age groups, it's different reasons why. But it's the general reason is it's like an insurance policy. You may never have to use it, but it's good to have in case something does happen. For young people, it's more important, particularly the Advanced Healthcare Directive, because if something catastrophic would happen to them and they were on life support, they'll be on life support a lot longer than an older individual like myself or yourself.
Always needling with the age there. Last week we talked about power of attorney and the Advanced Healthcare Directive, and you had pointed out that these are two things that can be activated when the person is still alive. But when the individual passes, those two parts of estate planning go with that individual.
Correct. Those documents die with the individual.
Die with the individual. The final will is different in that it does not kick in until the individual passes. Is that correct?
That's correct. So when you're, and we talked about it a little bit last week, but when you're planning your will, you really need to look at what assets you have. That's critical to look at. In Pennsylvania, you'll hear the word probate. Probate is a process where all the assets that are determined where they go by the will go through that probate process. Okay. But what's important to remember, and a lot of people this confuses them, a 401k or an IRA or a life insurance policy, they don't go through probate. They're beneficiary designation accounts. So there's sort of a contract between the person who's managing the money or the assets and the person whose money it is. And it says that we'll manage this, and when you die, we want you to name who you want it to go to.
Right.
So it's in banks they call them TOD accounts, time of death accounts. Okay. That'd be very similar. Those the assets in those accounts vest in the person at the time of the creator's death. So when you're thinking about estate planning, remember that you have to also look at who your beneficiaries are, who you've designated as your beneficiaries on those beneficiary designation accounts. Then the will control all your assets that aren't under that, or aren't controlled by those beneficiary designations.
Right. We, in the financial professional world, where I do some of my work, we actually have that come up sometimes, where someone has a will that may or may not have been edited recently and it states X, but their beneficiary on an insurance contract states something different. And we are always bound by the beneficiary on the insurance contract, because that is, at the end of the day, that's a contract, to your point. And so you're saying the will doesn't actually touch that. It's kind of the catch-all for all the other pieces.
For all the other assets, correct. And you bring up a good point. And with a lot of the rise of divorce, I can't tell you how many estates we're in where the ex-spouse is the beneficiary on a life insurance policy or an investment account, an IRA or 401k. And the person who now the decedent, they clearly did not want that. So you have to be, particularly if you've been divorced or there's an issue, you have to be very careful or cognizant of the fact that you got to change those beneficiary designations. The will, so we talked about, so if someone dies, what the will do is it gives someone authority, an agent, like we talked about in power of attorney or an advanced healthcare agent. This also names an agent. That agent is called an executor, or in the female, it's called executrix. It's old Latin terminology. And that person, what their job is, and everyone always seems to say, oh, well, I want to be fair to my children. It's there's no benefit to being the executor or executrix. It's just a job.
Right.
And the job is you take a snapshot of the total estate at time of death.
Okay.
And then you get the values of each of those assets, and then those would go on to the Department of Revenue tax form. Okay. So the executor, executrix, they take that snapshot, and then once they determine what the tax is, and the debts of the estate or the creditors, bills, then that net left over goes to the beneficiaries. Okay? Now, in a will, there's different types of beneficiaries. There's specific bequests. Those can be like a certain sum of money, like I want $5,000 to go to each of my grandchildren, or to this grandchildren, or to this person, or to this charity. They're typically specific in nature, not percentages. Okay? So you do specific, or if you had a stamp collection or an art collection, or my family's from the Pocono Mountains, so it was a big thing about hunting supplies and things. Those things would go to specific individuals. Those are specific bequests. Okay? And then you have what they call the residue, or it's like a pot that catches all the rest of the things that aren't specifically given away or bequested. They're caught in that residue. And that's a pot that catches everything. The residuary beneficiaries, which is the people who are going to take out of that pot, you could give, and that you could name them as percentages or whatever. And there could be charities in there, children, grandchildren, however you want to do it. But there's specific ones that have to be done, and then the residue is what's left over. So when people are planning, they need to think about, okay, who am I giving things to under my beneficiary designation? Who do I want to specifically give specific gifts to? And then who do I want to split what's left over?
And this is not including any investment account, like a 401k or a life insurance account. These are things that are owned, essentially. These are like possessions that can be divvied up in that way.
That are not in a beneficiary designation account, correct.
Understood.
So you name the executor, and then you name who you want specific bequests, and then...
And the executors or executrix is responsible for executing that, essentially, for making sure that that's what gets accomplished.
Correct. Their duty is to fulfill the instructions that are in the will.
Okay, that makes sense. What happens if someone were to pass without a will?
That's a great question. It would be Pennsylvania has by law intestate succession. Which that's the easy part, because that's broken out, and it depends upon what your family makeup is as to who gets which percentage, siblings and then your parents and then spouse and things. But the more sticky part is who becomes, and in that case they call it an administrator or administratrix. So the sticky part is people fight over that position. Okay? Now there's a fee that can be received by that person, maybe that's why, but I think it's really a power play. And so the difficulty is now you have the death of an individual, and now there's this bomb that goes off within the family, and if there's issues in the family already, this is going to exacerbate them. In addition, you also have to, particularly if there's a fight, you have to go to court and have that person named.
Is that somewhat like with the power of attorney and the guardian process?
Correct. It's just like naming the agent. it's a similar process as naming the agent in a power of attorney situation or a medical power of attorney situation.
And I'm assuming, just like with those two, the cost is a lot more if you have to go to court over it than if you just do it while you're still alive.
Correct. Now, in the case where there's agreement, for instance, if there's siblings and one says, I'll do it, and the others agree, there's paperwork has to be filed. It's not too expensive. It's not too onerous to get done. But the problem in that case still is the person who died, the decedent's wills, or how they wanted their assets to be distributed, is not being honored because they never wrote it down.
They never wrote it down. How legally binding is the will then? If it's the will points an executor and executrix, correct?
You're correct.
And then how legally, if that person has to execute what is wanted.
Correct.
Which is different if it's an administrator that's later appointed because there is nothing.
Well, no, the administrator would have to liquidate everything and it would be broken out via the intestate succession law.
Right. Okay.
So there's no leeway there. There's no chance for it to go the way that the decedent would want it to go.
Sure.
And it can be an expensive process, particularly if there's issues with how things should be dealt with.
But the will itself, if someone has a will, that will is legally binding.
Correct.
Okay.
Yeah, the interesting thing about Pennsylvania is, and we can discuss it in a little bit, is Pennsylvania has what they call an in-camera will that a lot of states got rid of.
Okay.
And it's a little more involved, and I can explain it to you in a little bit.
Okay, we'll do that. Don't go away. We'll be right back. Welcome back to Face the Issues. Richard, when we left off talking about wills, you had mentioned, I asked you about what happens if somebody passes without a will. We talked about the administrator or administratrix and that legal process. But you also mentioned the term the in-camera will. Could you go into a little bit more detail with that?
Yeah, it's a wild vehicle that's left over from the common law. I think it's probably a derivative of the British common law, I'm pretty sure. And I said it and then I have to remember the elements of it, but I'm pretty sure that the elements of it is it has to be written in the testator's hand, has to be signed by them, and it has to be dated.
Okay.
And I believe if you have those three elements, then that will can be taken to the Register of Wills, and that will is valid in Pennsylvania and has all the power and authority of a regular will. Wow. Normally in Pennsylvania, you have to have two witnesses, and then you have to have an affidavit afterwards indicating that the testator knew what they were doing and things like that. So we have other restrictions or other elements that have to be in a will to make it valid in Pennsylvania.
But this one has to be handwritten, so you can't type it.
Not just
sign it?
handwritten, has to be in the testator's handwriting.
Oh wow.
Yeah.
Okay.
Yeah, it's an interesting vehicle. It comes up every now and then, very rarely, but it comes up every now. It's sort of like one of those things that were left from the olden days.
And this is not nationally, right? Pennsylvania is one of the few states left that have this.
Yeah, I don't think it's in every state. I think it's because we're a commonwealth and our laws are very old.
Right.
I think this is one of those derivatives or one of those old things that are left over from the olden days.
Oh my goodness. So it seems like the easier path is just to get a will done.
Yeah, it really is, because then you're assured that what you want will be distributed how you want. I mean, one of the funny things is, and I think it was an in-camera will situation. I don't think it was a drafting mistake, but like they gave away all percentages to people, and it was 105%.
Oh.
So it was a huge fight as to the beneficiaries as to, well, how can it divide an estate 105 times? Yeah, 105%. So one of the advantages of getting your will drafted is the attorney will help you go over that and hopefully be specific about making sure that you cover all the things, beneficiary destination accounts as well as those who will pass under the will.
That makes sense. One of the other things that we have brought up in passing over the conversation is the idea of a trust. What is a trust? There was a big push maybe 20 so years ago where people were selling trusts and a lot of people were buying trusts or getting the trusts. But there's also a group that says trusts aren't necessary. What is a trust? Who benefits from a trust? What do we need to know about trusts?
Yeah, so trusts are it's like a corporation. It's an entity that's created that manages, in this case, usually assets, cash. And there's all sorts of different opinions, and I sort of have to say a disclaimer, even on the other parts, a lot of this stuff, the law is the law, but attorneys all look at it a little differently.
Sure.
So, with trust, there's an even broader spectrum of opinion as to how things have been done. Now, 20 years ago, or I can't even remember exactly when it was, but it used to be that the federal allowable amount that you could pass from one person to another was $625,000. And then someone reminded me, and I do remember this, the old days was like $125,000.
Oh, wow.
Yeah, so it captured a lot of people would have to roll into the federal taxing matrix, which is like 40, the lowest is, we haven't done them in a while, but it's very high, and it can be very quickly up to 40, 50%. So people drafted trust to avoid federal tax.
Okay.
Today, we don't necessarily have that because the federal allowable is around 11 million. Then if you have a couple, you each get 11 million. You can pass your 11 million to your spouse, so it's like 20. So it doesn't capture a lot of people. But what we've seen today is the issue is the beneficiary's inability to deal with a lump sum, receipt of a lump sum payment.
Right.
And the story I always love to tell is I was with a couple, they were in their late 60s, early 70s. They had two daughters, I think in their 30s to 40s. One was married, one was unmarried. And we did a simple will. I mean, I said it's a simple will, it's a simple estate. They don't have any issues with federal taxes. I think the estate was $1 million or something. And so we were getting up from the table, and I said, well, listen, do any of your daughters have any issues with drugs or inability to handle money? And I'll never forget it. She said, or divorce, and she said, oh my gosh, they're getting divorced, and he said, oh my gosh, my daughter has a disease, bipolar disorder, and it allows her to spend money like water. So we unpacked and we said, well, let's talk about a trust. So really what lawyers typically draft trust for is what they call asset protection. Okay. And I like the trust where there's no payout provisions. In the old days, they used to do payout provisions, 25 years old to get a third, 35 years old to get a remainder, half of the remainder, and then so on at 45, 50, whatever. Now we do them where it's total discretion of the trustees to avoid someone who has an abuse problem or is going to get divorced to protect their assets in a trust. In a protective environment that keeps that money safe from creditors or from a divorce or whatever they may be dealing with. And so as people think about their estate, even in a smaller estate, even if it's $500,000, a child at the age of 20, 30 getting $250,000 is, and some children can handle it, many can't.
Right.
The first thing they buy is, on the male side, is a car, and I would probably say it's the same on the female side. Yeah.
If you have a trust, do you also need the will?
No, there is a way, if you can get rid of all of your assets via the trust, and I'm glad you brought this up because this is something I wanted to mention. Via the trust, you can pass all your assets in trust. In many states, Florida particularly, Massachusetts, California, New York, the probate process is very difficult and very expensive. Wow. Even if they don't have tax like Florida, the process is so expensive, it can be even more expensive than tax.
Wow.
Yeah, so like in Pennsylvania, if you had if a person died and they had a house, a car, and some money, the executrix would be named. They would list the house, they would sell the house, they would sell the car, and then they would liquidate whatever the cash is left over, and then distribute it to the beneficiaries. In Florida, my understanding of it is for a house, you need approval of who the agent is, then you need approval of the price, and then once you get a buyer, you have to have an approval of the ultimate negotiated price. So you have to keep going back into court, and it costs thousands and thousands of dollars. Yeah, we've had estates where there's a Florida property. We deal with Florida Council, and it's more expensive to deal with that than the rest of the estate. In Pennsylvania, they used to have these things called living trusts. Right. And there was these charlatans. One of the lawyers who used to draft them actually was charged, I believe, and criminally indicted.
Oh, wow.
Because that had to do with the issue of the illegal practice of law where he was sort of deputizing people to draft these things. But in Pennsylvania, it's not a big deal. The only thing you have to worry about is the tax rates, and they're not that high. The probate process isn't that onerous and not that expensive. So when you figure it out, it's probably for the majority of people, a trust isn't necessarily for asset protection as far as going through the probate process. It's really more about protecting the asset from the beneficiary wasting it.
Right. what is the difference between a trust and then you said a living trust? Where does that difference?
I don't know where they get in all frankness, I don't know where they get the term living trust. I think it's a marketing term more than it's anything else. But you can see that vehicle is great in Florida.
Right.
Because it avoids the probate
Correct.
process. In Pennsylvania, it isn't. I don't know, maybe because you do, but you do a lot of trust during your lifetime. So it's not necessarily that. I'm not sure where they come. But if your listener, your viewers should be aware when they hear living trust, think to themselves, do I actually really need this? Yes. And maybe they ought to get a second opinion.
Sure, because that's different than what most people are talking about when they say trust.
Oh my gosh, dismantling living trusts in an estate sometimes costs people more than it costs them to do them. And they charged a lot of money for these vehicles.
Wow.
Yeah, it was not. Now, in certain specific situations, it might be helpful, but in Pennsylvania, the probate process is not that difficult. It's not that onerous. It's not that expensive.
Right. One of the things you mentioned too is the estate in general. When someone passes, we talk about estate planning. Pennsylvania has something. I think we're one of the very, very few states that still have it, called the estate tax, or what some people affectionately call it the death tax. What is the estate tax?
Well, what it is you would do an assessment as a snapshot of all the assets and get a dated death value of all the assets, including those that are passing via beneficiary designation, and then all those things are taxed. So for a lineal descendant, it's 4.5%. It's 12% for other. There's another category of related parties, and then 15% for unrelated.
Unrelated.
Yeah, I mean, if it's an issue, if it's a very large estate, that can be an issue, and then we might have to do different vehicles to take care of that. But for the bulk of the estates that we deal with, between drafting and maintaining all these things and the costs associated with that, a lot of times it's just easier to just let the stuff pass through the estate, pay a little bit of tax, and be done.
Sure. There's also federal income tax that can be charged on some accounts that get picked up by the beneficiary.
The federal income tax comes in the income of the items that are, when they're sitting in the estate, sometimes they sit in the estate a long time and they generate income. But it's got to be a lot of income for you to have to do a federal income tax form. Where federal comes in is if you get a large estate above 11 million for an individual, 22 for a couple, then that gets to be.
That tax will kick in.
Correct.
That's good. This is good stuff, Richard. Thank you so much. Don't go away. We'll be right back. Welcome back to Face the Issues. Richard, thank you for all your time these last two episodes. To wrap it all up, what advice would you give viewers or clients about estate planning in general?
Yeah, I mean, the first thing I would say is that whoever they choose to help them through this process, they have to be comfortable with, because in the end, it's their documents. So make sure that you're comfortable with the attorney that you're working with, and that they seem to be receptive to what you're trying to do. And the second thing is to relax. I mean, with the onset of WordPerfect or Microsoft Word, we can change these things. It's not Moses on the mountain carrying down the Ten Commandments. Right. They can't be changed. These things can be adjusted and changed, and the important thing is that they have it.
Right.
I can't tell you how many times we've gotten an estate, and what the what the decedent wanted and what's going to happen are two distinctly different things. Right. So it's really important to get around to it and get it done, even if it's imperfect.
Sure. That's great advice. One of the things we like to do with our guests is we like to have a little fun, get to know them on a more personal level. And I know you spend a lot of your time volunteering with a group called ELM, Everlasting Life Ministries, serving meals to the homeless community, volunteering on holidays and throughout the week. Tell me more about that and why you do that.
No, yeah, thanks. ELM, Everlasting Life Ministries, I was in seminary and we had to adopt a ministry, and so we adopted ELM. And I got to know their mission and then their leader, who is Pastor Gus Alcall. It's really a neat ministry in that it's the tip of the spear. Christ calls us to serve widows and orphans and the poor, and this ministry does that. It's great in that they do, like you said, we not only do meals every Thursday for the elderly, but then on Saturdays we pass out about 100 to 110 bags of food for 100 families every week. And then we have a clothing ministry where we give out clothing on a periodic basis. We have a medical ministry to help those who are uninsured or have have issues medically. Basically, it all encompasses all the things that the working poor and the poor would need. What I love about it is you get to know the people there, and so you get to know. I've gotten to know some of the regular clients, so to speak, the homeless and stuff, and it's really rewarding. In all frankness, it's like anything you do in ministry. I think you give of yourself, but you get back more than you ever could give, and to be the hands and feet of Christ for people who are less fortunate in our community is one of the greatest gifts that God's ever given me.
Yeah, I know a lot of your family's involved with that too, right? I know your son Christian was telling me that he's volunteered when he's back from college and some of the holidays and things like that as well.
They do. Typically we do, because there's a Thanksgiving, Christmas, and an Easter meal, and they participate in that. It's a lot of fun. I mean, you get to know the people that volunteer all the time and the people who we serve. And so it's a lot of fun. It's a great blessing that God's given us.
Well, that's great. Maybe some of our viewers will be there next time serving.
We're always looking for turkeys around Thanksgiving. So
There we go. There we go. Rich, thank you so much for your time. And thank you to all of you for tuning in. Join us again next week as we unpack another issue. On behalf of all of us here at Face the Issues, my name is Sam Chen. Thank you and good night.